last note that came in, I don't know if you got a chance to read it. The impression it seems from the judge is that the defense might just wrap up tomorrow. I know it's, you know,
All right, welcome back to this latest part of tonight's edition of Wave Extra. Of course, breaking down this time the defense's expert witness and other testimony bringing up in the case of Brooks Lawson and Brooks Houck and Joseph Lawson, excuse me, pertaining to the presumed murder and disappearance of Crystal Rogers. So I'll make sure I get those names squared away. But a lot of interesting input from the people called up by the defense. And to break down all those different notes and details, of course, is our reporter Alina Noakes, who's been live all week down in Bowling Green, taking those notes in the courtroom. And I'm going to start as we send things over to Alina for the first question. So, Alina, we heard from two expert witnesses the defense has hired, and they sort of are parallels to other kinds of witnesses that the prosecutors brought up throughout them presenting their case. So talk to us a little bit about what it is they offered, and obviously the prosecution then having their chance to kind of poke holes in what they're having to say. So if you could touch on that.
Yeah, so I was actually anticipating that these expert witnesses would be brought up in the defense's case, mainly because they kind of alluded to it when they were asking questions of the prosecution expert witnesses yesterday, or really throughout the week. So let's jump into the first one, because I think it's the one that a lot of people have found very interesting, and it's that smell of a human remains inside Anna Whiteside's car. That's Brooks Houck's grandmother's car. Obviously, it was seized during this investigation. In the trunk, we've talked about this, in the trunk was a strand of hair similar to that of Crystal Rogers. And it was also cited by a couple of raccoon hunters on a hunt on the night of July 3rd on a gravel road that butted up to the property of the Houck family farm. Now, all these things tying this together, and then that smell, the human remains smell that a canine detected for law enforcement was something that I think was like the last little bit the prosecution wanted to do to round it all out. But today, the defense called up an expert witness, another canine search and rescue instructor who has a lot of experience through Katrina and 9/11 and the searches with dogs in those situations, who talked about whether or not he viewed that dog and his findings to be credible. So a couple of things to point out there. First of all, he just had an issue with the fact that the handler in that case didn't have any records to support the dog's training. He said they were lost in a move. But more than that, he talked about whether or not the previous analysis done by a forensic team on that car before the dog ever searched it had any impact on the results, on that scent that the dog detected. He argues that there were too many moving parts, like chemicals and other humans in that car could have affected the dog's sense of smell when it came to detecting that scent. But then the prosecution got up and asked, is it impossible that the dog would not detect decomposing body, human remains, even if a forensic team did not find anything like blood or bodily fluids? And he said it's not impossible at all. So that's something that he actually said after a little bit of pressing by the prosecution and the judge making him answer the prosecution's question to that end. He really didn't want to hypothesize, and ultimately did say that it's not impossible that that would be the case. So that's really the point on the canine perspective from that expert. We'll have to see whether or not the jury had any particular thoughts on that. One juror wanted to ask him and just confirm a detail that he had said. So they were definitely paying attention. The other one, let's break into, I'm going to try to keep it simple because it was the last witness that we heard from today. Very lengthy. The only one we heard from this afternoon, about 3 hours worth of testimony, and he talked about cell phone data. So it's not the last we've heard of this. This has been a big component of this trial, specifically around Steve Lawson and his alleged involvement. Now, I want to emphasize for our audience, because it's something that we've gotten a lot of questions about. I've seen it in our comments. People saying, how can physical evidence or digital evidence, rather, contradict someone's own words? Obviously, if you follow the case, Steve Lawson has admitted to his involvement in some ways, saying that he definitely did go to the Bluegrass Parkway, manipulate Crystal Rogers' car, and then take his son from that scene. But this jury does not get to know that. That's something, the reason why this trial was separated from his. They don't get to know that unless there is some circumstance, some instance in which anything he said could be brought up in this trial, and that's an open door kind of thing. And we talked with our legal analyst who says it's unlikely that it could come up unless there's something that happens that forces it to come up. So, or even a deal that would be made with him, and at this point there's no indication that that would happen. So the cell phone analysis and the dispute over it has been a really big talking point of this trial. We said from day one, the defense has argued that Steve Lawson was not on the Bluegrass Parkway, but rather on Boston Road, which runs parallel north of the Bluegrass Parkway. And it just so happened that his ex-girlfriend that he shared a car with stole back a car from him that night, July 3rd night, and brought it to an address on Boston Road. The defense argues that that is why his phone pings, but it's not on Boston Road, it's on the Bluegrass Parkway. Today, a defense witness named Adrian Lauf, an expert witness in this case as well, testified that it is his belief that Stephen Lawson was never on the Bluegrass Parkway, and he argues that the data supports that. Except there is a little bit of dispute there because the prosecution brought up that he was going off of what's called NELOS or NELOS data. Basically, it targets data on a cell phone ping from a larger geographic location. Whereas, we've heard during this trial Brooks Houck's timeline being kind of full of inconsistencies based on Google and Google locators, which basically track longitude and latitude and give a more precise address. NELOS data doesn't really do that, and he based his findings and his conclusion off of NELOS data. That's something that the prosecution's witness, Tim O'Daniel with LNPD, did not do. He said he doesn't trust it to be the most consistent or give the fullest picture, rather, versus some other data points that he used to form his conclusion and his opinion that Steve Lawson was on the Bluegrass Parkway. So we have these two conflicting narratives here, two conflicting experts, both which are assumed to hold weight because an opinion from an expert is deemed to hold weight in court. You can't really give an opinion from anybody else can't get up there and just give an opinion and the jury trust it. But an expert is supposed to have a little bit more weight considered when it comes to their opinion, which is why these experts are hired on oftentimes to testify on behalf of either the prosecution or the defense. So those two experts, I try to keep it simple. I'm going on a little bit longer probably. But those were the two big ones from today that really targeted that the two experts prosecution has brought up and clearly demonstrating how the defense is trying to chip away at some of the things the prosecution has introduced in this case, Jose.
And it's important, Alina, and by no means don't feel bad about sort of adding as much of the nuance, because the jury, for better or worse, is going to have to sort of parse through this as well. But they're also going to have to parse through, and gets me to another interesting witness we heard from today is, again, a piece, I say a piece, but a person who's connected to, again, multiple people whose names have been brought up in this trial, not connected to Joseph Lawson per se, but Brooks Houck's sister, so presumably, the shared sibling with Nick Houck, Rosemary Houck's daughter. We hadn't heard from her up until this point today in court. What stood out to you about perhaps, what she offered, why the defense sort of is trying to establish her, to lend some weight to their narrative, and how did the prosecution sort of take what she was telling the jury?
Yeah, I thought the defense's use of her as a witness was interesting for a couple reasons. She does know a lot about this family. Obviously, there's been that allegation that she is involved in some conspiracy, that there is a conspiracy involving the whole family. So they really used her testimony and some of the things she said to help support their version of events, which is that it's not. And I want to focus specifically, though, on the thing we expected to come up, which is those grand jury recordings. I think that's the biggest point we can really take away from today, because we did hear about those in the prosecution's case. They brought up them. I want to emphasize we weren't able to hear these recordings, really any of them, super well. The audio in the courtroom is kind of not great for if you're in the audience. The jury has to listen with headphones a lot. So some of what was said we didn't really get to hear much of until today when a transcript was read. And basically she recorded her grand jury testimony, which are meant to be kept secret, and other family members did as well. And we know obviously Brooks Houck also recorded his interview with the police as well, secretly. He did that secretly as well. We found that out last week. So these sorts of things cause the prosecution to ask, was there a coordinated effort by the family? Did you all agree, essentially, to record all your interactions and your grand jury testimonies? And she said no, she wasn't aware that anybody else was recording them until she saw it on the news later. But there's the question about what was heard on the recording then, because on the recording, right before she goes into the grand jury, she seems to not be wanting to record it. You can kind of hear that on the audio, but Brooks Houck seems to insist that she does, and says that Nick wants it. Now, it kind of ends there because it's very garbled. There's no clear indication of what he's going to do with it and why he wants it, but he does mention Nick. She says she doesn't recall that conversation and kind of questions why Nick would want it and what he would do with it, because she said he's not very good with electronics or phones. So that's something she spoke to today, distancing herself from it all and from Nick as well. And I don't really know the goal necessarily from the prosecution asking if she recalled that conversation, except to show that she said that they didn't know anything about it, but Brooks is telling her to record it. So that was a big part of today, but then the defense really wanted to emphasize a couple other details. We've heard from a witness who accuses Joseph Lawson of saying essentially that they were going to take out Crystal Rogers' teeth, shave her head, and then let the hogs do the rest. That was a direct quote we heard from a witness. And the defense, Brian Butler, asked her if they had hogs at the Houck family farm. Now, it's important that he asked that question of her because the Houck family farm is the alleged murder site in this case. And she said they didn't. They had little pink pigs with black spots at the time. Take with that what you will. Outside of that, we also heard her experience or perception of how this investigation over the last 10 years has gone. The defense, I think, in this way trying to humanize their perspective, in that the prosecution has been out for the Houck family since day one. Specifically, they asked her, when did the accusations against her family start? She said immediately, so much so that accusations and threats caused her immediate family, like her kids and her husband, to briefly move to North Carolina. They have since moved back to Bardstown, but she, during that time, was accused by law enforcement and the FBI of being directly involved. They're making accusations of her doing certain things or being certain places, and she had to tell them that and produce photos, which we got a chance to look at today, that she was with her family on July 3rd, the night that Crystal Rogers was last alive, in Louisville at the Kentucky Science Center and the Louisville Slugger Museum. And then she says that they left to go back to Bardstown roughly after 7 o'clock sometime, 7 o'clock p.m. So I think her testimony, with so much questions from the prosecution, them really trying to target that grand jury testimony, things like that, and her time and place orientation with her involvement exactly on the night of July 3rd, and the accusations that had been thrown out there from law enforcement in the past, the jury had a lot of questions. We heard several from them, and not all at once. They kind of like, once she'd answer one question, they'd come back and have another one. And so we really heard about kind of their questions surrounding her timeline of events. That's where that July 3rd more specific timeline comes from. And then we also heard from her about Eli, the youngest, the son of Crystal Rogers and Brooks Houck, and kind of the eye condition he had that caused him to have to wear like tinted sunglasses and have certain protections for his eyes. That I'm going to bring up as a big point here as well, because the prosecution has alleged that Brooks Houck got his windows tinted just before Crystal Rogers went missing. And they bring up the point, why did he wait until just before, when Eli was alive for 2.5 years at that point and had had that condition since birth. She said, though, she doesn't know why he would do that other than something must have happened to protect his son, and that Crystal had her windows tinted and she has her windows tinted as well. So those are some questions that remain about that tinting. And if you recall, I don't know how much detail we really got into it the other day, but Steve Lawson and Tammy Lawson were also said to have called tinting companies as well as Brooks Houck those weeks leading up to the night Crystal Rogers disappeared. So all these little threads that keep popping up and were asked of her today, the defense trying to work to dispute the claims the prosecution has made, the prosecution working to prove their point that there was some kind of conspiracy, that the things that they've said against Brooks Houck were indeed true. So these are the things that we discussed today with Rhonda McEvoy, over an hour of testimony, and I'm not sure if the jury got all their questions answered. Some were deemed inadmissible, and so the judge didn't allow them to be asked. So that's kind of where we were at. That was the summary of today's testimony. I think we've gone through all of it, Jose. Some more interesting. Cell phone expert kind of took a while.
No, for sure, and it all matters in the context of course, as we head into tomorrow, which you talked about too, Alina. Presumably that this may be the last sort of round on Thursday. The defense will use up the time they'll have during the day, but presumably that the jury will get to go into the holiday weekend, and the judge is going to have to tell them to be mindful so they can come to a decision next week, right?
Right. So tomorrow we do anticipate that the defense will wrap up their witnesses by 4 p.m. Central Time, and then we'll come back on Monday with a weekend off and start up jury instructions first thing, and then I'm presuming they're going to go straight into closing arguments and then deliberations, but I'm not for sure. But we do know for sure jury instructions start Monday. So that's the current schedule of events for what's left of this trial.
Okay, thank you so much for that breakdown. Our reporter, Alina Noakes, of course, has continued to break things down eloquently for us down there in Bowling Green. Appreciate all your time and, careful explanations of this, Alina, so we appreciate you. As we wrap up with Alina, we'll make sure we go to break and bring in our legal analyst, Leland Hulbert, to get his analysis on today's testimony and notes. And as we do that, we're going to thank Alina for her time. Alina, thank you.
Thanks, Jose.
the last note that came in, I don't know if you got a chance to read it. The impression it seems from the judge is that the defense might just wrap up tomorrow. I know it's, it can be one of many answers, but does that at all surprise you that it seems like they'd be ready to wrap up tomorrow?
It seems like they've gotten through a number of witnesses. So they're, as I kind of thought they would have a cell phone data expert and some other hired witnesses that they paid to be there and give an opinion. And once they get through those, I mean, there's not a whole lot of witnesses you would expect because the Commonwealth is going to call a lot of the eyewitnesses or fact witnesses. And then there was a family member yesterday, I think. So at the end of the day, unless they're going to call their clients, which it doesn't look like it doesn't surprise me they're going to wrap up tomorrow.
I wanted to ask you, and I know we're kind of jumping in different chronological order of this. It sounds like at the very beginning, what we heard was Brooks House's attorneys make their opening statement. Is it unorthodox, for example, like the separate counsel for Joey Lawson to have him make that statement at this point in the trial?
No, I think that this the you're talking about the opening statement he made, but yeah, so attorneys can reserve it. I've seen this tactic used before. In this situation, I actually think it's probably a good idea because you already have one side making an opening, and if your route is saying, well, your client is not as involved or Joey's not as big a part of this, then save that for after the Commonwealth's evidence, and then say, look, see, we told you they didn't prove anything against Joey, and here's why. And I've seen the strategy. I don't know how well it works, but it's certainly allowed to be used.
So you mentioned the profile of the witnesses the defense called up, and I guess it's disclosed, whatever they were paid to be there to offer their opinion. So, for example, in the one we heard, who was also an expert in canines and those searches, anything in the notes from his testimony that stood out to you as far as what he offered as kind of a contrast?
Well, I think he was trying to say that the cross training is a bad idea when you're training about is there a live body or a deceased body and that kind of thing. And the prosecution thought did a fairly good job of cleaning some of that up. And then of course you never really know how this sticks with the jury, but when you find out a expert was paid $10,000 to give a dog handler opinion, that's pretty high. And then I think the other expert was also paid around $10,000. And so that may make them lose a little bit of credibility, but ultimately, how deep was their science? How much are they experienced? There's a wide range of experts that attorneys call, and some are better than others. So they may have been worth the money, but I'm sure, the jury hearing that figure, it may cast some doubt on their opinions.
And to the point where it would benefit the prosecutors not to miss that opportunity. For example, I was looking at some notes when the defense called their cell data expert, and I guess you could see the pattern in which prosecutors were trying to sort of get at a phone statement or the data points regarding that. It makes sense that the prosecution would kind of know what they would bring up as far as the nuances of the science are concerned, but then to also sort of poke holes in that testimony, I guess, right?
Yeah, I mean, you have to. Most cases come down to a battle of the experts, and this one may not be any different because the cell phone data has been so relied upon, and I think it's being refuted in its reliability. But then the prosecution is coming back and saying no one ever said it was 100% reliable, but what it says is these consistencies are here. And then I saw the one point about the defense pointing out that, well, I think it was Joey Lawson or Steve, one of the Lawson's phones was saying there was 150 miles from where it was 17 seconds later. But then they came back and said, the data is not accurate to every second and to every possible location. You're looking for a pattern. And, both sides can interpret the data the way they want and have their experts interpret the data the way they want. But you also can tie it in with the facts, because I think if the defense to try to say the cell phone data is all wrong, that's fine. But I don't know if they're going to be able to get around the fact that Joseph Lawson, Stephen Lawson, Nick Hauk, Brooks Hauk, all these people were on or around this property in the day before, the day of, the day after, that time period. It's not like any of them are claiming they were in California when all this happened. So, the data might be more reliable when you take into account they're admitting that they're in the area.
And to your point that they wouldn't have had the alibi that, for example, they would have been somewhere out of state, but it just had like, it's hard, perhaps you'd argue, for the jury to ignore that the data is putting all of them together more or less in a similar date and timeline, right?
Right. And the Commonwealth has been accused of trying to manufacture a case. And then the defense is now going to be accused of hiring an expert to say what they wanted to say. So, it is important to teach the jury about this science or inexact science of cell phone data. And then, you know, whichever attorney can do a better job of simplifying that, I think they're more likely to follow it.
I wanted to ask you what was interesting, and maybe there's more interesting tidbits with Brooks House's sister when she was called up, but it sounds like, the defense trying to at least lose or take the steam out of the accusation or the allegation of the tinting in the windows, it seems, especially if it's someone with knowledge of what Crystal and Brooks's son needed. That, not to say that that changes the entire perception, but what do you think is the value in her having offered that?
Sort of depends. It sounds like a good idea to say, oh, well, that's why I got his windows tinted a week before because his son had bad eyesight. Well, that's may be true and maybe a good argument, but then also I think the prosecution came back, well, why didn't he do it sooner? I mean, any other person whose child has compromised vision and wants to get tinted windows and can afford it would do it that day. So I don't know if they can prove when this condition occurred. I don't know if I think it came up that Crystal and the sister or other people had tinted windows. And the question is, when were those put in? So when you start using a child or using something sympathetic, that can work until it doesn't. And if it backfires because you don't answer the question, well, why wasn't this done sooner? Or that doesn't really make sense, then all of a sudden you're even more, you know, dastardly, more of a liar if you're going to use your own child just to try to win your case. But I think overall, when I first started, I thought, well, that's a potential excuse. And then he can't answer the question, why didn't he do it sooner? Because he's not testifying.
And that would be a risk perhaps the defense does not want to take. And for the prosecutors to then, while Rhonda was still on the stand, it's interesting how Nick's name, for example, keeps coming up, even though unindicted co-conspirator, the terminology the prosecutors have been using. Again, what is the rationale behind that line of questioning to, even though it's not Nick sitting among the defendants, for her to also comment on her other sibling?
Well, I mean, I think she is trying to clean up some things, and she obviously knows her family as well as anyone. And if you're pro prosecution, you would argue that, well, you're kind of showing now the whole family's involved. And that's been an argument the whole time, that this wasn't a one man show. This was family helping family, and the family's all related to Brooks Hauk. And then the Lawsons knew Hauk or worked with Hauk as well. And then if you're the defense, you're saying, look, this lady was harassed by law enforcement and they tried to get her to admit to something or tried to say she was involved. Maybe she was, maybe she wasn't. So, what you're seeing with almost every witness now is a point counterpoint, because the prosecution knows it has to act vigorously when it comes to a defense witness, because they're the last witnesses the jury is going to hear from.
Up to this point, is there any reason to think we'd hear Lawson's counsel bring specific witnesses for them? Or will it still sort of kind of hinge more so on how can his need to establish his case?
It's strategy now at this point. So if there's any amazing witnesses for Joseph Lawson, they should call them. But they are, if their whole stance is they're pushing their chair back from the table, going, "You don't have enough. You don't have enough." If they rest and don't call any witnesses and just make an argument, that might further their theme that we're just not that involved. And they've obviously got an opportunity to cross-examine every prosecution witness and House witnesses. So, that may very well be their strategy. That look, we're not involved. We don't have any witnesses to call. We didn't spend $20,000 on experts because we didn't do anything wrong, or we can't afford it. I don't know what he's going to say in closing, but I could see him going in that direction.
Something I was going to ask you about, since it sounds like, we're coming up on what we presume will be the break. Things wrap up tomorrow, Friday, of course, a holiday. No one's coming into court. Before everyone leaves for the holiday, is it common practice for a judge to just kind of what might he be telling the jurors over a longer weekend, and then as they come back next week, do you think?
Well, it's a difficult situation for the judge because he's got to give them all the orders not to talk about it, not to look anything up on the internet, not to watch any news. But all these people are going to be with family. It's a holiday weekend. And what about a brother of a juror saying, "Hey, I know you're on that jury. Can you believe he said this or believe?" And we'd love to think they're not talk about it, but the reality is, do they do Google searches? Do they do some research? Do they talk to family? We don't know. I think we can presume it's happened. Will it happen with this jury? Nobody will ever know. No juror is going to stand up and say, "Oh yeah, I talked to my brother about this while we were on the boat on 4th of July." But I think you can assume that that may happen, and that's a risk you run by giving a jury a 3-day weekend apart. And I think it would also be the judge is doing the right thing as well, because no jury is going to want to decide a case at 5 p.m. on the Thursday before the 4th of July when they're all probably have holiday plans. So he's trying to be considerate of their time, and also doesn't want them to rush a verdict. And then they can be refreshed and hear the closings on Monday. But you're probably going to have a lot of them starting to make up their mind before closing arguments.
Just my own curiosity, and you can let me know if it's tougher to speculate on this, because it may just be about a perception, but you have all the experience to judge this from your position as best as you can. Is it worth trying to measure who's among the counsels, like who's come off as having the stronger positions? Is it worth even mulling over that or no?
Well, I mean, I think better lawyers have an advantage. I think that's typical, and that's with any other profession. The better the person is of their profession, the better they're going to do. But at the end of the day, I think all of these lawyers are well qualified, if not highly qualified. And the jury, when in doubt, lawyer tricks usually mean less than actual evidence. So all you want is the jury to follow the evidence and make a somewhat informed decision and try to come to an agreement.
I may ask you this question tomorrow just as a repeat, but once again, the sense that maybe this is also going to wrap up sooner than some might have predicted.
Yeah, I mean, I think it's, again, it's not really surprising given the first trial. It's probably about what we thought it would be, 2 weeks, maybe a total of 8, 9 days. I think that's fair. Could it be longer? Have you seen other trials that are similar that last 3 months? Sure. But I don't think there's anything wrong. I just think it's moving quickly.